There is a common misconception among many Muslims and non-Muslims that in Islamic law, a woman's testimony is half that of a man's, that a woman is intellectually less reliable than men. This misconception stems from the general application of one understanding of a verse of the Quran referred to as Surah Ad-Dain or Ayat Ad-Dain, that in Quran chapter 2 verse 282 to 283. Ayat Ad-Dain means the verse of debts. And the verse says that people should write down their agreements, they should get witnesses that are credible, but it also states that they should get two men to testify. And if they can't, then a man and two women, such that if one of the women is to err, the other would remind her. Some have concluded from this, therefore, that in all cases of testimony, you would want two men or one man and two women. And if you can't get one man and two women and it's only women, then you should get four women, the logic goes. A closer looking at the Quran and the Sunnah gives us a significantly different picture of the situation. Firstly, the understanding that witnesses are means towards protecting justice. The role of witnesses, the role of giving testimony is to convince the judge that justice is being protected, the truth is being told, and the facts are being represented as they really are. And so witnesses are really there as means towards securing and protecting justice and just dealings. Based on this, it is up to a judge to decide what testimony he or she regards as credible. And so even in cases where you may have four witnesses, if the judge is not convinced about the credibility or the competence or the character of a particular testimony or witness, it is up to the judge what to accept or reject, and when the judge feels he or she has been convinced. So when we look at these verses, we should look at other statements in the Quran and other indications in the Hadith regarding how did the Prophet and the early Muslim community understand the question of women's testimony. In cases where a woman was more competent than a man, or where women were more competent than men, the women's testimony was stronger and more credible than a man's testimony. So the testimony of a midwife or a woman in the case of mix-up of children at childbirth, Imam al-Nawawi, for example, says in such cases, it is only the woman's testimony that is credible, not a man's, because that is not a man's field. In fact, if a man was there, traditionally they would ask, what is he doing there? So in areas where women were more competent than men, a woman's testimony was stronger than a man's. Where the woman's testimony was the same as a man's would be in areas where the women were as competent as men, like in the authenticity of Hadith. And in areas where men were more competent than women, then the men's testimony was considered more credible than that of a woman's. So in the first instance, for example, we find at the time of the Prophet, peace be upon him, a man who was married with all the witnesses and everything was told by a woman that she was his foster mother, that she had breastfed him. The man took the case to the Prophet ﷺ and told him what this lady had said, and the Prophet said, what else is there other than divorce? In other words, the one woman's testimony was enough to convince the Prophet, peace be upon him, that this marriage was not valid, because in Islam, you are not allowed to be married to a foster brother or a foster sister. In the authenticity of Hadith, when a Hadith is narrated by Umar. On another hadith is narrated from the Prophet by Aisha. No hadith scholar says the hadith by Umar is more valid or stronger, more reliable than the hadith by Aisha. The scholars would actually want to find out what the topic is about. If the question was related to the domestic life of the Prophet, peace be upon him, then they would consider Aisha as a more credible witness than Umar. If, however, it was about political alliances or laws on the battlefield or some aspect of public life where Umar would be more competent than Aisha, then they would take Umar's hadith as being stronger. So we find, even among hadith scholars, and in a number of cases which are discussed in more detail elsewhere, where the woman's testimony was the same as a man's, we realize it is because the credibility and the competence of the woman was the same as that of a man's. In Quran chapter 2 verse 282 and 283, where in the Ayat Dain we find the Quran prescribing 2 men or 1 man and 2 women, we realize firstly that this is not a general verse for all cases, as we can see in the areas of hadith and places where the woman's testimony was either the same or even stronger than that of a man's. So it is important firstly to recognize that with all the various cases in the Quran, in the case of li'an, where a man accuses his wife of zina or says that the child does not belong to him, he swears and bears testimony 4 times that it is not his child, and she does the same, and her testimony cancels his testimony. In other words, it's not treated as a case of zina. So we find of all the cases in the Quran, there is no distinction between the man or the woman's testimony. It is only in Quran chapter 2 verse 282 that is specifically on financial loans. And some scholars have given reasons, sociological reasons. Scholars like Ibn Taymiyyah, Ibn Qayyim have explained that this is because this was not an area of competence for women. That traditionally women were not involved in such business loans and business transactions. This does not mean buying and selling transactions, but loan transactions, which usually in Islamic finance were mudaraba or musharaka. They were tied to some kind of partnership business. So when we look therefore at the objective of the verse, the interest of the verse is in protecting justice. And so carefully looking at the verse, as Taha Jabir Alwani points out, the verse says 2 men or 1 man and 2 women, such that if one woman forgets, the other would remind her. In other words, if the second woman doesn't forget, then it is 1 man and 1 woman. The second woman is needed more as a guarantor because of an area that women were not traditionally competent in. And so in conclusion, before we conclude that a woman's testimony is half that of a man's, we should remember there are places where the man's testimony is half that of a woman's. And in situations where roles and professions were very much decided by gender, that women were midwives, women were nurses, women did the cooking, men did the battles, men were the fishermen, men were the hunters. In such societies, then where you had certain genders more competent in areas, we would expect therefore that witnessing in such areas would be biased in favor of protecting justice, and you would have the men's witness or testimony stronger than women's in areas where men were more competent. Where women were more competent, we would expect a woman's testimony to be stronger than that of a man's. But where they were of equal competence, either because they all go to the same schools, same education, same experience, then the testimony would be the same. The critical thing for the judge is to remember the objective of testimony is getting to the truth and deciding on who is the most competent on a particular case. But it is not correct to say that in all cases the man's testimony is stronger than the woman's. It is a case-by-case issue, and it is up to the judge what convinces him or her on a particular case.